Hey everyone, and welcome to the second half of class. Welcome to the third section of our study of the United Nations. And for the next 2 weeks, we're going to be broadly examining the relationship between international law, human rights, and international courts. Now, we could have an entire class focused on international law. And the literature that is out there is just, enormous. For the purposes of this class, and simply as a way of keeping within the theme of introducing you all to the workings of the United Nations, and more importantly, the capabilities of said organization, I want to keep it simple, I want to keep it moving, and I just want to give you sort of a broad assessment of what is out there today in contemporary international debate. Right, so this is by no means exhaustive, and it is far from definitively authoritative. But, as I said, I want to, just give you a quick lecture. I want to give you a general idea of the main things that we drew from the readings this week. And by the way, if you look at the syllabus and you look at the readings that are available, you might have noticed that I had pulled one of the readings from this week's assignments. I don't think any of you are really going to be upset about one less thing to read. But I just realized that a lot of the stuff on international law can be very dense. And for an undergraduate class, no insult to any of your intelligence here, a lot of the stuff can sometimes be tedious. And this is stuff that's a little bit more reserved for, let's say, a graduate course or a more dedicated examination of international law. So, for the sake of keeping it short, sweet, and to the point, this lecture should hopefully give you a good sense of, I guess, some of the problems and issues surrounding international law, which, right off the bat here, we have a couple of things to note, right? When we talk about international law, right, we oftentimes like to think in the normative sense that this is the highest form of authority, that these represent some of the broadest morals and principles that shape and guide not only global politics today, but a global understanding of what should be, right? After so many wars and catastrophes and problems, right? We like to think that international law is based on some set of positivist principles and philosophies. And, that's not entirely false when we think that international law, really represents a collection of pre-existing agreements, principles, arrangements, and mutual understandings at the international level. In this sense, right, international law, and I put this in quotes because, the big thing to understand for this lecture is that international law is law only insofar as member states recognize it as such. Right? So in this case, international law is regarded as more of a moral standard, but it isn't always legally enforced. And this is, one of the first things that we have to understand about international organizations, specifically the United Nations, is that until it becomes a world governing body, which is not going to happen in my lifetime and it's not going to happen in yours either, what we understand as international law remains really agreements and principles that are taken on faith, right? If not the honor system, because there's little effort, there's little emphasis that can implement, that can defend, that can somehow enforce. That's a better word of looking at it. Enforce international law. Powerful states can get away with whatever they want. Smaller states might be beholden to sanctions or legal condemnation, but more often than not, the biggest transgressors of international law tend to be the larger states. And they oftentimes will frame their foreign policies within a certain way that might acknowledge some breach of diplomatic protocol, but what they're doing is in the greater good or the collective interest of a whole bunch of people, which is a very nice way of masking, national interest, right? So great power politics, specifically between the United States, Russia, China, Iran, Turkey. I wouldn't necessarily put Turkey and Iran as great powers, but certainly regional powers, oftentimes will refer to international law when it suits their interests, and they'll overlook international law when it doesn't. So international law is something that we really just put in quotes, right, is really just a collection of a number of pre-existing ideas, principles, codifications that, we like to follow, but oftentimes without enforcement, that's really all that it is. It's just it's a sense of moral guidelines. And so in this sense, international law also isn't representative of the most current moral imperatives. Right? This is another thing that we have been discussing within, let's say, the last 15 or so years, in that we like to think that international law is synonymous with what is moral. And for those of you who had me in the international organization class last semester, right, we spent a good deal of time talking about the difference between that which is legal and that which is moral. And oftentimes we like to think that what is moral should be backed by some legal precedent, some legal codified understanding. And that's really the problem in studies of law, right? Legality might not always mean morality. And, if there is an argument made to, defend something, uphold something, propose something that is somehow morally right, and it needs to somehow be defended by some legal codification, this usually only happens after that which is moral has been somehow abused, dismissed, and some transgression has taken place. So issues of, let's say, human rights, for instance, which oftentimes fall under more so what is moral rather than what is legal, right? They need to be framed within the existing concepts of international law in order to be upheld and defended. So there's lots of times where you have, NGO advocates that are talking about the need to address the growing crisis of human migration, or the spread of abuse against women and children refugees. Or we can talk about, on a more institutional sense, the need to acknowledge the self-determination of self-declared territorial units like Palestine or Abkhazia or Kosovo, right? Because it's right. Because the people want it. And that's all fine and good until, right, the legal, advisors come in and effectively remind you that, the way the world works, whether it's at the domestic level or it's at the international level, is that, morality doesn't really, find some place to take effect until we find a legal way in which it can be implemented. So when we talk about human rights, when we talk about sovereignty, when we talk about transnational challenges in the 21st century, we need to understand that there's a lot of moral imperatives that we need to face, but the legal parameters kind of limit us to what we can feasibly do and how far we can go, in the current age. So if you want to be optimistic about this, you might think to yourself, okay, well, if it's not legally on the books, let's try to make it as such. So when the issue comes up again, we have some way in which we can address it formally and diplomatically. So in this sense, when we make sense of international law, right, we need to understand that it is legitimized by international organizations that in themselves are legitimized by sovereign states. And herein lies the big problem, right? Herein lies one of the, enduring problems and limits of something like the United Nations. Even the European Union, if we were to go, to look at a more regional organization. And that is the element of enforcement and implementation remains problematic because these organizations don't have that capability, right? The United Nations was not designed to be a world government. The United Nations was not designed to be a federal authoritative body made up of 193 states. It is still, from its inception in 1945, only as powerful, as impactful, as influential as the member states make it out to be. And, let's take this even one step further and say, let's say the most powerful states, right? Somalia could, push for the United Nations to have much more authority. And that's nice as far as Somalia is concerned. But when it comes to, let's say, the United States or France or Russia, we know that there's, a certain shelf life that this debate is really going to have. So this, sort of gives us a, let's say, a more empirical understanding of what we should do versus what we can actually do, right? And this is one of the big problems in international law, because those who study it, those who are experts in the field, might feel that we need to be more morally proactive. But what we can do under the current institutions, under the current statutes, right, gives us far less capability of taking action than what we would otherwise like. So in this sense, before we even get into any of the specifics, international law, which, as you've seen, I'm still putting in quotes because, international law is something that is, used and brought up, only in certain situations, remains evolving works in progress that, like our models of intervention and our discussions from the last couple of weeks in human rights, right? They develop only after a failed crisis has necessitated re-examination and reform. So, for instance, when we talk about the difference between comprehensive and targeted sanctions, right? The understanding of targeted sanctions can only really become a thing until we realize that comprehensive sanctions fail, right? They don't do their job. And it is somewhat of a Pyrrhic victory in the sense that we realize that targeted sanctions are something that we should consider only after, 2 to 2.5 decades of comprehensive sanctions against Iraq proved to be an utter failure and ultimately resulted in, destroying the state. International law also reminds us that it risks being used and abused by powerful states, right, to advance national interests within the diplomatic language of collective security and the need to, quote unquote, do something. So in other words, when international law is brought up, and it is usually brought up as a way of showing that there is a transgressing state out there doing something wrong, violating certain principles and normative ideals, it usually comes from another state that sees this targeted state as a rival, as problematic, and in this sense, it's not used objectively, but it's kind of brought up conveniently. Right? This is the other inconvenient truth of international law, is that we will really only sanction and punish a country that seems to be in violation of something when it is in the national interest of another powerful state to do so. And thus, finally, international law continues to revolve around debates surrounding intervention, defense of human rights, and an increasing importance of international interdependency. Right? So international law is something that will be brought up in, discussions in the General Assembly. It is also something that will more often than not be brought up when contentious politics, come to the fore in the Security Council. But we need to kind of remind ourselves, unfortunately, that these debates remain mired in power politics, which prevents them from evolving beyond the normative into the empirical. So in other words, what I'm trying to get at here is that while there is a growing understanding and legitimate acceptance of some kind of international legal set of parameters that states, non-states, corporations, groups, whatever, global actors have to work within, that understanding remains still very normative and rather subjective. Now, that's not necessarily bad news. it means that there is a growing collective feeling that international law should supersede the legality and the sovereign capabilities of one state over another. But the fact that I said the word should still means that it is within a debate that has not yet become universal. So in other words, international law comes up when it's convenient to be brought up. And international law will be somehow disregarded, ignored, or downplayed when it does not jive with the national interests or policies of a powerful state, either a powerfully global or regional. And so with that sort of prologue, right, I want to examine really three things in this lecture. Right, and so we're going to be looking at these three issues in the order in which international law goes from the most empirical to the most normative. When we talk about issues surrounding statehood and international participation, this is pretty much the most codified set of international legal principles, right? And the short, form of it is a state is internationally recognized if it is able to achieve membership in the United Nations, right? So at current count, there are 193 countries that make up the UN. Therefore, there are 193 legally sovereign entities in the world. The reality is that there are at least 24 more territorial entities that claim some form of sovereignty. Some of them possess a number of international recognitions, but because they are not recognized as such by the United Nations, membership in such organization remains indefinitely postponed. So international law here doesn't necessarily solve the issue, but it raises a number of points on what exactly constitutes sovereignty. And how does that understanding of sovereignty make or break participation in a number of international organizations, not just the UN, but also others in which membership doesn't necessarily have to be based on sovereignty, but still membership in these larger organizations like the UN or the EU leaves a number of territorial entities out. The second issue is human rights and sovereign jurisdiction. Now, this is kind of a halfway between full empirical legality, and this is where kind of debates begin to start creeping in. Human rights are things that have been effectively codified in Geneva Convention, the UN Declaration on Human Rights, and even the UN Charter, right? If you remember when the concept of collective security was extended to cover more than just military issues, but also the idea that human well-being and a general standard of living needs to be promoted by the United Nations. And if these are not met, better yet, if they are being actively violated against by a state, does a state effectively abrogate its right for sovereign jurisdiction in the name of international intervention to address the issue, either just to coax the state to think differently or to militarily intervene as a form of preventative measure? Right. International law here begins to become much more a topic of debate at the Security Council. And finally, when issues concerning the regulation and control over transnational challenges and crises are considered, right? And here we're talking about environmental problems, climate change, migration, the status of women. These are much more normative elements that certainly fall into the realm of the need to do something, the need to address something. In fact, in many situations, I'd even go so far as to say that things like climate change and environmental protection is far more of a pressing issue than the question of whether or not Palestine is a state. But international law remains rather vague. There might be some declarations, there might be a few conventions that are met, there might be a few guidelines that states can follow, but it's really up to the individual states to decide where and when to implement them. So the point to be made here is that international law is not as defined or as rigid as many of us would like to think. In fact, it's still an ongoing process. It's a struggle to get international law to supersede that of individual member states. So let's kind of begin with, I would say, the easiest and the most straightforward, although not the least problematic. And that is the idea of statehood and international participation. So it's worth reminding everyone again, and this is, I think, a self-evident fact here, that the United Nations is comprised of sovereign states, right? As I just said, 193 by last count. Now, this is something that most people don't really think about because the issue of sovereignty is something that most people regard as I've already mentioned, self-evident. But in the last 25 to 30 years, there have been a number of challenges to the previously, unchallenged idea of what constitutes sovereignty. And this is through a number of self-declared territorial entities that have broken away from their parent state and either unilaterally declared independence or sought the support of one or two powerful countries to, keep them on the map, albeit in a different shade of color from the parent state that they broke away from. And so when debates surround the question of whether or not Kosovo or Taiwan or Palestine or Abkhazia or Northern Cyprus possess sovereignty, it's here where we kind of delve into the literature on international law and sovereignty and realize that there's really two approaches, declarative and the more recently used constitutive. Now, traditionally, declarative sovereignty is a real simple way of understanding sovereignty, right? It is the ability of a government to execute authority over the territory it claims and over the people that reside therein, right? So this is largely based on the principles of the Montevideo Convention, which was convened in 1933, and kind of gives us the traditional base of what constitutes a sovereign state. And according to the convention, right, this is in the article, first article of the Montevideo Convention, the state as a person of international law should possess the following qualifications: A, a permanent population; B, a defined territory; C, government; and D, the capacity to enter into relations with other states. Now, this is not rocket science. This seems pretty obvious. Effectively, if one is a political entity that has a monopoly of control over a territory, is able to govern said territory, then it is, ergo, ipso facto, whatever Latin you want to use, right, a state. And the Montevideo Convention was largely convened to retroactively, convene international sovereignty to a number of states in Latin America that had, for the previous, century or so, declared independence against Spain and Portugal. So this was largely designed for former colonies that had, fought for their independence, achieved it, but needed some kind of official entry into the international community of nations. Now, this in of itself effectively says that all you have to do, right, is kind of declare authority over a piece of territory, plant your flag, say that this is the country X, and you are inherently sovereign. That's not how things really work in the more modern age. In fact, it's rather interesting that the Montevideo Convention was convened during the era of the League of Nations, in which the League already said that sovereignty is something that is inherently special to states. So in this sense, what Montevideo really does is simply grant the status of formal statehood to colonies that had already, for years, decades even, right, fought for independence. This is different than constitutive sovereignty, in which case Sovereignty must be recognized through legally binding agreements and international organizations that recognize, respect, and uphold the territorial integrity of the states. So in this sense, constitutive sovereignty builds off of the principles of declarative, but adds two critically important elements. The first is that it's not enough to just simply plant a flag and call yourself a country. You have to be formally recognized by some international legal body, whether that's the League of Nations or even more so now, the United Nations. The second is that since the 1950s, right, there have been a number of movements that have tried to break away from an existing state, especially states that are already in the United Nations. So whether it's, East Pakistan that breaks away from the rest of Pakistan, we call it Bangladesh now, the collapse of Yugoslavia, secessionist movements in Corsica, in Catalonia, in Basque Country, and elsewhere, right? It's not enough to just simply declare yourself a state and get that. You need some kind of collective approval. And the other thing that you need is some kind of coordinated activity with the parent state that you're breaking away from. See, these secessionist movements are not necessarily colonies anymore, but they're taking place in the core territory of an existing sovereign state. So if there is going to be a breakaway region that wants to form a country on its own, constitutive sovereignty also stipulates that it needs to have, first and foremost, the approval of the host state, the parent state. If the parent state's okay with it, then the UN really doesn't have any major issue to be said here. And what's more so is that constitutive sovereignty really reflects a longer tradition of coordinated sovereign integration, right, that began, as far back as the Treaty of Westphalia in the 17th century. But if you remember our discussions in this class about how institutionalization grows from, let's say, the Congress of Vienna to the Congress of Berlin, the League of Nations, the United Nations, right, even, in the 19th century, it really wasn't until some international congress, some conference, bestows recognition on an entity that effectively was governing on its own for decades, right? So, the Berlin Treaty of 1878 effectively recognizes the already de facto independence of countries like Serbia, Montenegro, and Romania. The only difference is that now they have that certification, right? Whereas beforehand, sovereignty could be contested, these entities could be invaded, territories could be taken away. Once you have that international recognition, right, your borders are now legally codified. So in that sense, constitutive sovereignty turns de facto power into de jure leadership. And this is a big, big, big thing, which explains why a number of breakaway movements that want to call themselves a state, and in some situations even have better sovereign control over their territory than some UN members like, Chad or the Central African Republic or the Democratic Republic of Congo or Somalia, right? All four of those have UN membership, but they're not exactly, cohesive states. Breakaway entities like Northern Cyprus or Kosovo or Abkhazia can, have a better control over their territory, but because they're not recognized legally as a sovereign state, because the host state that these territories have broken away from refused to grant recognition, this leaves them in some kind of legal limbo, right? So, the precedence of constitutive sovereignty in relation to international law really begins at the San Francisco Conference, right, which acknowledges, right, the evolutionary practice that I've been mentioning since the 19th century. But if you remember in the beginning of class at the San Francisco Conference, and this is especially true with the Lebanese and Syrian delegates. Now, these were formerly French mandates that had kind of gone rogue after France is taken over and conquered by Nazi Germany, right? The mandates are just kind of left to their own devices. So they attend San Francisco in the hopes of being recognized as full-fledged members. And they don't want, A, to go back to France after the end of the war, and B, they don't want this legal limbo halfway house to be put into a trusteeship council, which can somehow prolong their status of finally evolving into an independent state. So the reason why I'm bringing this up is that the pressure to make all UN signatories independent states effectively says that constitutive sovereignty now has legal precedence over the more loosely defined declarative practices. So by avoiding being an ambiguous status as a colony, soon to be former colony, and also noting that many colonial powers like the French and the British refuse to even, think about this, it not only eliminates the continued need for the trusteeship council, but it kind of seals the fate of do-it-yourself secessionist movements that without the formal approval of the UN will not receive the status of sovereignty, international legal sovereignty. Now, we don't really see this as a problem until 1991, when a number of countries begin to break up, like the Soviet Union, Yugoslavia, and to a lesser extent, Czechoslovakia. The thing to note here is that when the Soviet Union and Yugoslavia break up, they break up into constituent federal republics. So in other words, the 15 countries that emerge out of the Soviet Union, right? Russia, Ukraine, Belarus, the Stans, what have you. They all become independent states, but with the pre-existing internal federal republic borders. Now, this is kind of a special situation within within legal debates, within legal subjects here, in which a federal state can break up into its constituent republics, but the important thing to note here is that the borders do not change. So if you were to think about this, for instance, let's say the United States was to break up into, 50 independent countries here. New Jersey was to secede, New York, whatever. The future state of New York would look like the borders of what New York is today, right? Same thing with New Jersey. So when Yugoslavia and the Soviet Union break up, the idea is that the international community will tell these emerging states, you will be a state within the pre-existing federal border. However way that border is drawn, it doesn't matter whether the borders are justified or not. We're not changing borders around. What makes these so-called parastates different is that they are not existing constituent entities. They might be breakaway territories that have been seized through some kind of military campaign. At the absolute best, they might have been some kind of autonomous province within an existing federal republic. But the thing is that the borders are not recognized as constituent. But parastates don't really care about this, right? And when we see the rise of secessionist movements in, let's say, Nagorno-Karabakh and Transnistria, and then eventually a secessionist war in Kosovo, we begin to realize that this arrangement isn't necessarily a sinecure for all of life's problems, but we don't know what to do with these entities. They somehow seize control of a territory, but we don't want to recognize it as such because we don't want to reward effectively bad behavior, or we don't want to reward secessionism with statehood because that kind of then gives a green light to everyone else saying, hey, the borders of current countries are kind of a free-for-all now, and the good people at Rand McNally are suddenly going to have a lot of time on their hands redrawing maps as opposed to just simply updating them from the previous year, right? So this kind of leads to what I call, a frozen conflict of a parastate, right? And within international law, parastates exist outside of them, right? A parastate is a territorial region that has unofficially declared some form of sovereignty, right, but lacks the formal international support and recognition to achieve full sovereign independence. So it possesses the de facto authority of declarative sovereignty, right? It is a government, it controls a piece of territory, it governs over the people, that's all fine and good. But it lacks the de jure legality that constitutive sovereignty will bestow. And that is because parastates do not coordinate their activities with the host state which it broke away from. And within this, right, the host state, the parent state, however way you want to call it, actively seeks to prevent the parastate from emerging onto the international arena as an independent country. And vice versa, the parastate will do everything possible to prevent the host state from regaining control. So from a legal standpoint, this is a violation of an existing country's sovereignty and territorial integrity. So, the moral issue could be that the separatist movement is fighting for self-determination, for independence. They're fighting against human rights abuses they can certainly bring up. And that might have a moral discussion. But when it comes to the structures and the capabilities of what is legal, right, one cannot recognize a unilaterally declared entity within an existing country that is a constitutive member of the United Nations. Because if that is the case, then suddenly the notion of sovereignty and one of the primary principles of the United Nations in defending the sovereignty of its member states goes out the window, right? Now, you might think to yourself, well, what about intervention, right? What about human rights violations? We'll get to that in a minute, but just kind of sneak preview here. Intervention does not necessarily mean that the sovereignty of a country is going to be violated. There can be boots on the ground, there can be some kind of military intervention, economic sanctions, coercive measures, what have you. But at the end of the day, if the borders of the country are not changed, then sovereignty is, in the grand scale, right, still defended and upheld. Now, the reason why this is important to talk about is because in the last 20 to 30 years, the number of these so-called parastates have actually been on the rise. So, prior to 1990, we had maybe Northern Cyprus, and then, of course, what we'll call sort of de-recognized states, like Palestine or Taiwan, or to a lesser extent, Western Sahara. These are unique situations where each one has a specific backstory. But the point is that these are territorial entities that function on a day-to-day basis, but they are just simply prevented from entering the UN because of some larger, political, issue or obstacle. Northern Cyprus is probably the most controversial because it was effectively an invasion of an existing country, Cyprus, by the Turkish army. Turkey recognized the independence of Northern Cyprus in 1983, but no other country has done since. And as such, Northern Cyprus just kind of remains this really, really unique and increasingly old, relic from the Cold War period. But the more secessionist examples of parastates, like Kosovo and Abkhazia and South Ossetia, Transnistria, Nagorno-Karabakh. There's just 5 to begin with. We can even talk about the possibility of maybe Catalonia wanting to secede from Spain. All of these definitely challenge not only, collective security of states, but also challenge the understanding of sovereignty, right? And in some of them, Catalonia could probably do quite well as an independent country, sometimes even comparatively speaking better than Spain itself. But will Spain recognize Catalonia? Of course not. Will Serbia recognize Kosovo, even though it's, economic dead weight for Serbia? Of course not. It's a matter of principle. It's also a matter of making certain that you can't just simply rise up and go all declarative sovereignty anymore, right? So parastates are entities that possess declarative sovereignty, but they don't have constitutive, the more legally codified constitutive. To a very quick lesser extent, parastates today can also be terrorist states, like the Islamic State, or in some cases, we might even have breakaway entities that are taken over by terrorist units. So in 2012, 2013, if I'm not mistaken, what year, there was a secessionist movement in the African country of Mali, and the northern two-thirds of the country broke away and declared itself the Republic of Azawad, which would have gone ignored and unnoticed if it wasn't for a affiliate of Al-Qaeda called Ansar al-Din taking over effectively the area and turning it into a potential terrorist hotbed. The same thing happens in the 1990s with sort of the do-it-yourself breakaway movement in Chechnya, which is in Russia, which eventually sort of morphs into sort of a proto-Al-Qaeda affiliate group calling itself the Republic of Ichkeria. If you're a terrorist parastate, trust me, there is absolutely no recognition, no legality whatsoever. You're going to run the risk of a military invasion. But it kind of gives one a larger sense of thinking about, well, what constitutes sovereignty if these unconventional entities can somehow practice it better than existing UN states. So, as I said, a parastate is an entity that must have formally and unilaterally declared independence from an existing host state, right? It's not through coordinated secession, and it is not some autonomous region that just kind of, goes rogue, but it is something that is done in violation of another state's sovereignty. It might exist for years, right? Some parastates do a very, very good job of kind of existing through the cracks of, legal interpretation, and it does so through continuous sponsorship from at least one powerful country to keep it, alive. So the United States effectively, keeps Kosovo on the map. Russia supports Abkhazia, South Ossetia, Transnistria. Turkey supports Northern Cyprus, right? Now, sponsorship can include, but it does not require, recognition. If the sponsor country recognizes the country, it makes the parastate's status doubly secure. But it doesn't further its quest for eventual universal recognition. Parastates can sometimes have only a handful of recognitions, but if they come from powerful countries, we end up more with a frozen conflict than anything else. But on the other end, right, we have parastates like Kosovo and Taiwan that have multiple recognitions. Palestine, not Taiwan. Palestine has over 120, 130 recognitions. But there's two countries that oppose its statehood, the United States and, naturally, Israel. That's all that's needed to keep Palestine out of the UN as a full-fledged member. It does have observer status, but that is largely, if not entirely, because the United Nations already recognizes some proto-Palestinian state within the borders of the 1967 ceasefire agreement. No such luck for an entity like Kosovo, which at one point enjoyed close to 115 recognitions, is now down to somewhere around 96, 97. It's actually lost a few over the past few years. Those recognitions that it lost didn't really do anything for them. These are small countries. As long as Kosovo is recognized by the U.S., Germany, and the United Kingdom, its frozen conflict is certainly guaranteed. But a parastate is an entity that claims independence, and it has to be opposed by at least one other powerful state that blocks its entry. So we've already talked about the U.S. Opposing Palestine. Russia opposes Kosovo. China opposes Taiwan. Some of them might be able to enter regional organizations. Hong Kong is a member of the International Olympic Committee. Kosovo is a member also of the IOC. It is a member of FIFA. It got into FIFA. I believe it is also a member of the International Monetary Fund. Could also be a member of the World Bank. It is not a member of the EU, and it has no chance of getting into the EU because statehood is predicated on statehood, right? You can be a member of the IOC because territories are IOC members. Hongkong's not a country, but it's in the IOC. Kosovo was able to play that and was able to get into the IOC, but if membership is not formally predicated on legal sovereign statehood, you might be able to get through the cracks. Kosovo became a member of FIFA on the same day that Gibraltar was offered membership. And, Gibraltar has got, I don't know, what 30,000 people that live there. It's a little British territory off the coast of, off of Spain. So if membership is not formally predicated on statehood, yeah, these parastates can enter these organizations. But, the big ones like the UN, NATO, or EU, international law effectively says you got to be a state. You got to be like a full-fledged country. And you're not really a country unless you get into the UN. So if Kosovo was to ever get UN membership, then by that point, NATO and EU membership would be pretty much, down the road. But be that as it may, right, the parastate is an entity that has successfully prevented, right, the host country from regaining control, either through military deterrence, especially if you've got, powerful allies abroad, a political stalemate because you've got those countries pushing for membership, sovereignty. You got others opposing it, and it just kind of, falls into this, debate deadweight within the Security Council. And also just the idea of if these host countries were to ever regain control over the territory, the costs of reintegration are pretty high. And more often than not, the only way to really do it is to send in the military, and that just, brings a whole bunch of risks in and of itself. Usually comes along with ethnic cleansing. So in many situations, retaking the parastate is something that the rest of the international community really doesn't want to do. So a parastate possesses declarative sovereignty, but lacks constitutive. And so in placing this within our discussion of international law, right? So what's the point of all of this, you're probably wondering. When Kosovo declares independence from Serbia in 2008, Serbia decides to take this case to the International Court of Justice, right, in The Hague. And rather than being a formal one country is suing another, because Kosovo is not yet an internationally recognized country, they have to kind of frame it in a certain way. So Serbia kind of goes to the ICJ in seeking really an advisory opinion. And that opinion was based on the following question. Is Kosovo's unilateral declaration of independence in compliance with international law? Or is it illegal? That's even a better thing. Is Kosovo's declaration of independence illegal? A violation of international law? That's really what it was. And after, months and months of debate on both sides, the ICJ comes back with a rather ambiguous answer. And that is Kosovo's unilateral declaration of independence was not illegal. Was not illegal. It doesn't mean that it's legal. But the reasons behind it is that there's nothing currently on the books of international law that prohibits an entity from declaring independence. So technically speaking, Catalonia can declare independence. New York State can declare independence. Texas can declare independence. Crimea could, whatever it is that you want, right? New York City could declare independence from the rest of the country if it wants, right? There's nothing illegal about doing that. But it is up to international bodies and states themselves to decide whether that declaration should be recognized or not. So what the ICJ said, and this is where international law comes down really on the side of existing sovereign states, is that declaring independence does not mean that sovereignty is automatically granted, right? You can't just simply, go all Michael Scott, like, on The Office and say, I declare independence, and suddenly you're a country. No, you can have a flag, you can have an anthem, you can have a whole bunch of people that want to do that. But the ICJ's ruling basically said that declarative sovereignty can be declared, but constitutive sovereignty does not automatically follow. That's what the ICJ ruling said. It doesn't say that Kosovo has to be returned to Serbia right there. But it also says that Serbia and any other country like it is under no obligation to recognize Kosovo's sovereignty, even if that sovereignty is sound and empirical. So in other words, international law says a state is nothing without recognition. And even then, you need international recognition. So if the ICJ proved anything to these quasi-legal disputed territories is that unilateral acts outside of coordinated international law and without the cooperation of the parent state will get you nowhere. You will not get UN membership. You will not get EU membership. You don't get NATO membership. And you're constantly struggling to prove to everyone that you're capable of acting like an independent state. What this also does, if you really want to go legal, is that it legitimizes the existing practice of uti possidetis. Right? Uti possidetis is a Latin term that, in so many words, says what we kind of explained a couple of slides ago, and that is a federal state, if it disintegrates, can disintegrate to the local state level. So in other words, former Yugoslav republics like Slovenia, Croatia, Bosnia, Serbia, Macedonia, and Montenegro, there were 6 republics within Yugoslavia. If the country is going to break up, these 6 republics can become their own states because they were constitutive federal republics. And that means that the borders that they had during the Yugoslav period is now going to be the same now. The same thing with the Soviet Union, right? The 15 constituent Soviet republics can become states in and of themselves. But if there are existing territorial problems, disputed borders, we're not changing the internal borders of any of these emerging states. Kosovo was a part of the constituent Federal Republic of Serbia within Yugoslavia. So if anything, right, Kosovo should be afforded wide degrees of autonomy, power sharing, all sorts of things in coordination with the main government in Belgrade. And that was something that was extended, right, to arguments concerning Catalonia with Spain. If Catalonia wants to exercise more authority, it's got to go through Madrid. If Scotland wants to exercise more authority, it has to go through London. And if any of them want to pursue independence, they need to get the approval of the parent country in going through that. Right? So if there's like a referendum, for instance, on independence, people go to the polls and they say, do you want to be independent or not? Yay or nay, yes or no. If the parent country says, I will recognize and honor the results, then a state can break away from an existing country and be recognized. But this is within international law because it's within the coordinated activities of another country's sovereignty. Montenegro was part of Serbia up until 2006. And within a referendum that the government in Belgrade had said they would recognize, right, the referendum comes back by the slightest of majorities to give Montenegro independence. Serbia does not protest. They do not contest. They recognize Montenegro's independence, and within a month or two, Montenegro gains UN membership. Kosovo declared independence back in February of 2008. So we're going on now, more than 10 years, 12 years, 13 years since that happened, and Kosovo is nowhere near getting into the United Nations. So in this sense, right, international law is pretty clear, pretty empirical, and in many situations kind of overlooks arguments about morality, about normativity, about what should happen. You could make the argument, yeah, sure, Kosovo should be an independent country. Look at what happened in the 90s. But then you have to apply that argument to every other breakaway group. And are you going to then change the borders of Georgia, of Azerbaijan, of Cyprus? By that measure, are you going to change around the borders of Bosnia? If Albanians don't want to live in Serbia, shouldn't Serbs not want to live in Bosnia? And that's why international law says, no. You know what? Keep the borders as is. Internal federalization, power sharing, that's it. We don't want to, the minute that somebody goes, with a marker on a map and starts changing borders is when every other Tom, Dick, and Harry secessionist movement wants to do the same thing. All right, so much for, sovereignty. Let's talk about the second aspect, human rights and sovereign jurisdiction. Now, this is something that we've been looking at already for the past couple of weeks, especially when it comes to questions of intervention and sanctions, right? The ideas of human rights as an extension of collective security, and by this point, this should be pretty familiar to all of you, was something that was proposed by Latin American and Middle Eastern delegates at the San Francisco Conference of 1945 as a way of expanding the understanding of what collective security meant. Right? The developing world, the global south, effectively wanted the UN to be more than just simply a military alliance, but to be truly a global institution for development, for human well-being, and for promoting a sense of liberalist philosophies and principles. Now, that in and of itself is all fine and good, right? There's no question about that. That's in the UN Charter. And even during the Cold War, when the UN was kind of hamstrung between US and Soviet foreign policies, there was this positive attitude that the UN is there for some greater good. But questions begin to arise when we ask how to punish transgressing states. Right? And it's one thing to say that you uphold the principles of human rights. It's another thing when you feel like you actually have to do the upholding. Right? When you realize, when it's known that there's a country that might be engaging in harsh domestic tactics, is that a violation of human rights? Right? When do we see this as an international concern? Right? And this is part of ongoing, as I said, discussions, writings, research on intervention, sanctions, diplomatic isolation. What do we do? And what constitutes intervention? Is it military? Is it diplomatic? Do we put pressure on the country? What about sanctions? What about targeted sanctions? Do targeted sanctions work in line with human rights being violated? Right? Do we just kind of go after the leadership financially, while they're still discriminating against, constitutionally discriminating against an oppressed minority, religious, ethnic, linguistic, what have you. And then, of course, is the idea that if we diplomatically isolate the country, is that going to help either, right? Diplomatic isolation just kind of entrenches the abuse because a country can be isolated, but that doesn't necessarily mean that the country is going to starve. It doesn't mean that the country is going to fall apart. So, when we talk about human rights, right, we understand, right, that within international law, there is this belief that, since I would say not just 45, but definitely even the League of Nations, no state, this understanding, no state holds unlimited power to do what it wants to its own people, and that sovereignty implies a dual responsibility. First, to respect the sovereignty of other states, but more so to internally respect the dignity and the basic rights of all the people within a state. So this second aspect, right, is that states can't just do whatever they want internally anymore, but in an increasingly globalizing and interconnecting world, if a country is abusing a certain constituent of its population, does the international community at large have a legal right to intervene? This was the argument that was put forward by the British and the Americans for intervening in Kosovo in 1999, right? The idea is that Serbia, Yugoslavia cannot just simply open fire. It cannot just persecute a minority that might be restless, that might be contentious, but you have to, at the absolute least, work with them politically. Try to find a compromise. You can't just meet terrorism with counterterrorism, because this will eventually spill over to include other countries within the region, specifically Albania, Bosnia, Greece, maybe even Turkey. So even though, right, the UN Security Council did not approve of intervention, and it certainly did not approve of Kosovo's statehood in 2008, normativity begins to take place here alongside, right, great power politics. So I don't want you to think that human rights are just simply, whatever we want to think at the moment, right? Normativity, right, is still based on codified treaties, agreements, and declarations. So as I've mentioned, right, the Geneva Convention effectively is one of the oldest and most widely regarded, documents that effectively say, among other things, captured soldiers need to be treated humanely, and when you are at war, you need to know the difference between combatants and civilians, right? So you can't just, open fire and just kill discriminately. The UN Declaration on Human Rights is also something that, Tony Blair and Bill Clinton were saying, look, this is something that is built into the UN Charter. It's built into the UN's existence. So if we sit by and do nothing, then the UN has lost, a good degree of legitimacy. And of course, this argument being made in 1999 sort of comes on, the complete ignoring of what happened in Rwanda in 94 and, the quick abortion of any real intervention in Somalia in 91 or 92. But be that as it may, all right, I just want you to know that, international law and human rights certainly exist. Right? Even within, let's say, common laws or understandings of conduct and diplomacy, the understanding that, as early as the foundation of the League of Nations, right, waging war is a crime, right? So there are some, yes, there's still subjective understandings, but as states take these understandings more and more to be part of their foreign policy and their international cooperation, then yes, international law does have some obligation, to intervene when crimes against humanity are taking place, right? We were introduced to this term crimes against humanity at the Nuremberg trials of 1946 in direct response to the Holocaust. And this is also the time that we end up getting the term genocide. Now, this is not the first time that this happened. Already, understandings in the early 20th century surrounding what it was retroactively coined the Armenian genocide had taken place, with this pervasive feeling that this can never, ever be repeated again. And, it's one thing for the Armenian genocide to happen, all the way on the periphery of the, crumbling, dying Ottoman Empire. But for genocide of such systemic industrial capability to happen in the heart of Europe within one of the most advanced and civilized countries, right, provides like more of a legal imperative than is needed to say, look, from here on out, these types of human rights abuses need to be met with some legal consequences, some legal repercussions to say the least, right? Hence the Nuremberg trials putting a number of individuals in the dock for orchestrating this type of brutality. Whereas beforehand, this was just simply seen as the horrors of war. Now, this is something that can be, that is prosecutable, which is reflected in the ICTY, the International Criminal Tribunal for the former Yugoslavia, in which a number of former combatants and political leaders, Serb, Bosnian Muslim, Croat, and now even Albanian, are being indicted and put under trial for, if not pulling the trigger, then providing the political framework or the environment for the trigger to be pulled. So in this sense, right, the idea of needing to do something, even if it's in response to something that's already been done, is being based on existing codified treaties, agreements, and declarations, and is continuously developing over the years. Unfortunately, the development happens after another crime against humanity takes place, but you can kind of see, right, it's kind of the halfway between legal precedent and, the beginnings of a normative subjective argument about when to apply them and where. And finally, probably the most open-ended, but that's largely because it's the most recent, and we're still trying to figure out how to deal with it, is in regulation and control over transnational crises. Now, what issues are transnational, right? Things like the effects of global capitalism, especially economic restructuring that leads to wide-scale levels of poverty, which can also spill into problems of environmental concerns, additional human rights violations, risks to collective security, and of course the proliferation of international terrorism. To that, I can also talk about migration, climate control, the rights and security of minorities, women, children, the lack of clean water, the lack of proper infrastructure within countries that provide proper health care, proper well-being. All of these are issues that go beyond the capacity of any one country to handle, and as such, it just kind of is defaulted into the lap of the United Nations to deal with. The thing is that all of these issues are part of the UN's influence, but lays bare the limited role that the UN can do. So in other words, the UN possesses the legitimacy, the normative subjective legitimacy to issue broad-scale declarations and goals for tackling and remedying transnational problems, the developmental goals, the Paris Climate Accords, the Kyoto Protocols, the Istanbul Convention, all of these things relating to the environment, the rights of women, and just general principles of well-being and social welfare of the 21st century. They're all ambiguous. They're all open-ended. And they all rely on individual states to make good on. So authority rests still within a limited capacity due to national policies, capabilities, and competing economic and political interests. So for instance, we can talk about whether or not clean air is a human right and it should be protected by international law. And to that, let's add clean air and clean water. Everybody should have access to clean air and clean water. This, of course, presupposes countries are not going through their own 21st century industrial revolution. So the pressures to produce and to modernize and industrialize and the demands put on countries like China and India and Bangladesh and Indonesia and Malaysia and others in providing the cheap goods for consumers in the developed world are going to have an indelible effect on the water quality, on the air quality, especially when pressures of globalization are forcing these countries to deregulate as much as possible in order for them to get the bid for the factory or for the manufacturing license. And so in that sense, unfortunately today, economic development and modernization kind of take precedence over environmental regulation and climate control. And this we have found to be, the biggest obstacle in, providing some kind of cap on the number of carbon emissions in the world, As global demand for manufactured goods goes up, carbon emissions are going to just skyrocket. The temperature is going to increase. We're not even talking about manufacturing. How about the idea of just, the global demand for meat? These macro, beef farms or whatever it is, the amount of methane that is released from the cattle and the pork just has, an indelible effect on the air quality, on the water quality. So, in this sense, international law is still trying to play catch up with these regional transnational problems. The closest that we have right now are really guidelines. The Paris Climate Accords are good to follow, but they provide just, the absolute bare minimum. The Istanbul Convention, which is a series of, principles and goals for not only promoting the rights of women, but protecting them from domestic abuse. States can pull out of them at moment's notice. You want to talk about the Istanbul Convention? Turkey just pulled out of the principles that it hosted the damn convention in. So again, a lot of these transnational issues still rely right now on the decision of individual states. Right? So you can see this, sort of progressive decline in legality for transnational concerns, right? When we start at the more empirically codified concept of statehood and membership, international law is pretty certain, pretty clear, and pretty rigid at the same time. This was not really an issue up until about 20 or so years ago. The concept of statehood and sovereignty was clearly laid out, first at the League of Nations and then later at the United Nations. Right? Sovereignty is something that needs to be declared. It needs to have some kind of de facto control over territory, but equally important, it needs to be internationally recognized in order for it to have any legal legitimacy. And this was a fail-safe that was put in to protect existing sovereign countries from all sorts of secessionist and rebellious movements. It was also something that was the legacy of the soon-to-be post-colonial era, in which territories like India, Iraq, Lebanon, South Africa, Egypt, and others were very adamant about making certain that there was no ambiguity between colony and sovereignty. There was no halfway house. There was no transition that could somehow be reversed or in some way be manipulated by the parent country. And so this leap from colony to independent states kind of left no room for these quasi-legal entities that become something in the 1990s and afterwards. So that's why a number of these parastates are left in indefinite legal limbo, because membership is either you're a sovereign country or you're not. And if you're not universally recognized, and if you have one or more powerful country preventing you from passing through the Security Council and becoming the 194th member, then you better make peace with your frozen conflict indefinitely. Either that, or you go back to the drawing board and you renegotiate your status within the parent country. Because we have yet to think about expanding the understanding of international law for non-sovereign territorial authorities. Right? There has yet to be within the United Nations some kind of membership for slightly less than legal. Right? Palestine has observer status, and that is largely because the General Assembly was able to offer that in the absence of any, American veto at the Security Council. It's something that just, was able to be bypassed. But also, I think because Palestine is one of the few cases in which the UN already recognizes the state of Palestine within the 1967 borders. This is not the case for Taiwan or Kosovo or any other entity, which, at least as far as Kosovo's case, was approaching at some point enough recognitions to maybe garner observer status. But they wanted to go for broke, right? They wanted membership or nothing. And within that time, membership has receded. And I'm not exactly, sure. I'm pretty certain that, Kosovo will not go back to Serbia in the, in the immediate or long-term future right now. But its status as not entirely independent, not entirely, part of another country, is something that warrants observation for increasing the idea of membership for, again, regions. And this can, also be extended to Northern Cyprus, to Abkhazia, to Catalonia, to maybe even Scotland, if they fail in a referendum for independence but still want to get into the European Union. Whatever the outcome is, right? I'm just sort of waxing hypothetics right now. The elements and the structures of international law regarding sovereignty and statehood are clear, and oftentimes they get in the way of would-be countries. Things become a bit more ambiguous, a little bit more arbitrary, once we start thinking about human rights. Human rights laws exist. They are on the books, but their implementation is what is arbitrary, and it oftentimes relies on the enforcement of powerful states, right? So if human rights want to be dealt with in some far-off corner of the world. The UN might point to it, but unless there is another country that is willing to do something about it, then that's really all that the debate is going to include. Are human rights violations taking place in China today? Yes. Are they taking place in Russia? Most likely. Are they taking place in Turkey? Absolutely. Are they taking place in Saudi Arabia? Yes. Here's one. Are they taking place in the United States? Right? Let's extend that discussion. It's one thing to say, yes, they are. It's another thing to actually act on it. And unless there is a coalition of states willing to do so, then, international law doesn't really mean much if it simply raises awareness but doesn't do anything about it. And this is, I think, made apparent mostly when we examine the more open-ended debates surrounding transnational crises and concerns. Right? Just like human rights, this is up to individual states to follow or ignore. But in this sense, there's no Geneva Convention, there's no Declaration of Human Rights, there's no UN Charter with which to base itself on. More to the point, we are really looking at interpretations, subjective matter, normativity. So if there is some need to quote-unquote do something in promoting human development and well-being in some war-torn country, or whether there should be some international law that protects refugees, confirms the status of women as equal citizens, that mandates a certain degree of water quality or air quality or something like that, right? It's yet to be codified. Right? It is yet to be written down. We are just simply at the developmental goal stage. Right, or at the the Paris Climate Accords, the Kyoto Protocols. Take a look at these names. The language once again relies almost exclusively on the goodwill of countries to make good on it, or just simply ignore them altogether. So with this discussion here, I mean, as I said when I started out, this just only touches the surface of a vast amount of literature concerning not just international law in general, but the specifics of the three things that we've examined: states and sovereignty, the whole question of human rights as itself, and more developing, pressing issues that we just will lump as challenges to global security, transnational challenges and crises that we know exist, but we have yet to find any legal precedent with which to act beyond just simply the need to quote unquote do something. Now that might be that might be enough for some countries, some groups, some leaders to act. But when you have something to fall back on as a legal precedent, as legal justification, that gives you a little bit more of authority in the international arena. So things that we're only just beginning to talk about in this second half of class. I wanted to just touch on these subjects within the readings that I know could be a little dense, but I once again welcome our collective discussion in class on Wednesday. And if they are anything what the past couple of weeks have been, we're going to have a really good hour and 15 once again. So enjoy the rest of the weekend, everyone. I'll see you in a couple of days. And if you have time, right, start reading up for next week where we delve even further into the specifics of human rights. All right, take care, everyone.